The Supreme Court has just issued a new order in a major case concerning the Second Amendment Preservation Act, often called the SAPA law, and it's one that's been closely watched across the country. Let's break down exactly what happened, what this decision means, and where things go from here. Before we begin, if you'd like to support this channel, the best way to do that is by subscribing. It really helps us continue bringing you updates on important constitutional and firearm-related cases. Now, this particular case involves the state of Missouri and its Second Amendment Preservation Act, a law that's been at the center of a long legal battle. Missouri passed this law in 2021. It was designed to assert the state's own interpretation of the Second Amendment and to limit how much its law enforcement agencies could cooperate with federal authorities in enforcing certain federal gun laws. Essentially, Missouri's law prohibits state officers, agencies, and officials from helping federal agents enforce any law that the state believes violates the Second Amendment. The law even created a civil penalty, meaning citizens could sue a state or local official if they helped enforce a federal law that Missouri considered unconstitutional. The idea behind it was to give more power to Missouri citizens to hold their government accountable when it came to protecting gun rights. However, the law immediately faced opposition from the federal government. The Biden administration sued Missouri, arguing that the law was unconstitutional and interfered with federal enforcement powers. When the case went before a district court, the court sided with the federal government, striking down Missouri's SAPA law entirely. Missouri appealed the decision to the Eighth Circuit Court of Appeals, asking for a temporary stay so that the law could remain in effect while the appeal was being considered. When that was denied, Missouri turned to the Supreme Court, seeking emergency intervention. At that stage, the Supreme Court issued an 8-1 decision denying Missouri's request. Justice Clarence Thomas was the only one who supported stepping in to block the lower court's ruling at that time. After that denial, the case went back to the Eighth Circuit, which heard full arguments and eventually upheld the lower court's ruling against Missouri, again striking down the SAPA law. Missouri wasn't finished. The state filed another petition asking the Supreme Court to review the Eighth Circuit's decision, arguing that the lower courts had misinterpreted both the law and the Constitution. Missouri maintained that its law was based on the principle of anti-commandeering, meaning that the federal government cannot force states to use their own resources to enforce federal laws. Missouri also claimed that the Eighth Circuit's reasoning was flawed because it treated non-enforcement of federal laws by state officials as though it were active interference. One key argument Missouri made was that the Eighth Circuit agreed the structure of the SAPA law itself could be valid, but struck it down anyway, simply because it was connected to Second Amendment protections, which the court found problematic. Missouri said that this reasoning ignored the constitutional right of states to decide how their own law enforcement operates in relation to the federal government. This case took another turn when the Trump administration took over the Department of Justice. The new administration initially delayed filing a response in the case for several months, but when it finally did, its position was somewhat mixed. The Trump administration maintained that parts of Missouri's SAPA law were invalid, agreeing with the lower courts in part. However, it also suggested that the original judgment against Missouri might have gone too far. In its filing to the Supreme Court, the Trump administration stated that after reviewing the case, it believed the lower court's decision may have been too broad, possibly blocking portions of Missouri's law that were in fact constitutional. Specifically, it mentioned concerns that some parts of the SAPA law reflected legitimate non-enforcement of federal laws, something protected by the anti-commandeering doctrine. The administration indicated that if the Supreme Court denied Missouri's petition and sent the case back to the lower courts, the Justice Department would consider releasing parts of the judgment that had been entered against the state. The Supreme Court appeared to accept that reasoning. In its most recent order, the court denied Missouri's request for emergency review, effectively sending the case back down to the lower courts. However, this doesn't mean the case is over. It will now continue at the district court level in the Western District of Missouri. The U.S. government, through the Trump administration's Justice Department, has stated it may release parts of the prior judgment once the case is officially back in the lower court's hands. Recently, the Supreme Court issued a notice confirming that the petition for review was denied, and that notice was sent to both the Eighth Circuit and the District Court in Missouri. That formal notice means the denial is now officially recorded, and the case is being returned for further proceedings. The next step will depend on whether Missouri files a motion asking for portions of the earlier judgment to be lifted, allowing some parts of the SAPA law to take effect, while the rest continues through the courts. What happens next is crucial. The Trump administration told the Supreme Court that it would take steps to correct what it viewed as overreach in the original ruling, but now that responsibility lies in their hands. The administration isn't legally required to release any part of that judgment. It was simply a commitment made in its argument before the court. So, we'll have to wait and see whether they follow through or decide to maintain the full judgment against Missouri's law. Even though the Supreme Court declined to get directly involved this time, there's still a chance for parts of Missouri's SAPA law to survive. The fight isn't over yet. The case will continue in the lower courts, and depending on how those proceedings unfold, it could eventually make its way back to the Supreme Court again. This case remains one of the most important ongoing battles over state sovereignty and the Second Amendment. It highlights the tension between state and federal power and will likely set an important precedent for how far states can go in refusing to enforce federal gun regulations they view as unconstitutional. As developments continue, we'll keep following this story closely. If you want to stay updated on this case and other issues affecting the Second Amendment, make sure to like, comment, and subscribe. Doing so really helps support the channel and tells YouTube that you value content like this. You can also check out the videos on your screen right now. These are other updates and legal breakdowns that you might find informative and helpful. Thank you so much for watching and for all your continued support.